Pete Wishart.
Thank you very much, Madam Deputy Speaker. And can I refer to my register of members' interests? And can I also, belatedly, Madam Deputy Speaker, welcome you to the chair? I think your welcome to the chair is perhaps the No campaign's loss when it comes to the constitutional question, but I think that's something that we could possibly welcome, Madam Chair. Can I start my remarks by generally welcoming this bill? I've managed to have the great pleasure of speaking in most of the IP debates in the House in the course of the past 13 years as a Member of Parliament, and I've had the great pleasure of introducing a couple of these debates myself. And I think this is the first time ever that we've had an exclusive, dedicated IP bill in the time that I've been in the House. And it, of course, gives us this incredible opportunity just to assess the value of IP-supported business and industry to the general economy. And it makes such a fantastic contribution, IP-supported industry. 4.3% of our GDP, as the Minister said. And of course I'll give it to the gentleman.
I'm very grateful for the Honourable Gentleman giving way on that point. And I think he makes an important point about the importance of IP rights. Does he think there's some value in the need to educate most of the country, if you like, and particularly young people, about the value and the importance of IP rights?
The Honourable Gentleman is spot on. So much more could be done in terms of educational initiatives. And I've seen some important work done. When you go into schools and you see children, school children, trademarking with a little smiley copyright symbol, works that they've done, the start of understanding and appreciating that this is work of value. Even though it's just school drawings, there's an intrinsic intellectual value to the things that they've produced. And if we could try to get that message across that intellectual property is a right as much as a property right, and if we can get that respect and that type of culture and feeling about it, we'd be making great strides forward when it comes to all of this. Because it is important. You know, we found in the last report that, just in the last couple of weeks, that there's been growth in the creative sector by something like 8.6% in recent years. Now, that compares to growth in the general economy of only 0.7%. It's the UK's fastest growing sector, worth something like £71 billion per year. And as the Culture Secretary said herself, so much of our cultural and creative endeavour rests on important intellectual property rights, and she's absolutely spot on when it comes to this. It's our creative industries that are growing ourselves out of recession. Imagine growing our economy on the backs of the creativity, the talent and imagination of the people of the country. What a fantastic way to grow our economy. And this is why it is absolutely fundamental and of great importance that we get the intellectual property framework right. Now, we've not done too much wrong in the course of the past 10 years. The UK remains a brand leader. We're in the top 3 of practically every discipline, cultural discipline in the world, whether that's music, film, television, publishing, whatever. The UK is there in about the top 3. We're doing something right. We're doing something right also because it comes natural to people in these areas. We're just creative naturally, and this is what is reflected in the great output that we've seen in the course of the past hundreds of years in terms of contribution to invention, to talent, and to creativity. So we get something right, and we're able to protect it, so we've got to be very, very careful as we progress forward with our intellectual property rights and how we may be able to address all this. We must make sure that we tamper with this at our great, great peril, and we've got to be careful how we progress. Now, the genesis of this bill goes back to November 2010 and the Prime Minister's great Googlesburg address. And I'm sure people will remember that, because I can remember coming home one evening and I couldn't actually believe I was seeing a UK Prime Minister on the TV talking about intellectual property. I hadn't seen anything like that again. It was great that he took an interest in intellectual property, and it was the first time ever, I believe, that I've seen a Prime Minister addressing the whole issue of IP in the way that he did. But what also interested me was what he was saying, and I wondered, what on earth is he on about? Because what he was trying to say in his basic premise when it came to debating and discussing intellectual property is that we wouldn't see the emergence of a Google in the UK because of our restrictive intellectual property laws and copyright framework. That was what we said. He didn't say if it was a good thing to have a UK Google, but that was the very clear thing that the Prime Minister said in his Googlesburg address, that we would not be able to create a Google in the UK, and he said something about our IP rules and laws being restrictive, and they needed to be addressed and they needed to be fixed. Now, I don't know who was advising the Prime Minister at that point. It certainly wasn't the honourable member for Hove and Portslade, who is now the Prime Minister's advisor. And I know the honourable member for Hove and Portslade, and he wouldn't be advising the Prime Minister to say anything like that type of nonsense about the need for a Google to emerge in the United Kingdom. He would be saying something much more sensible and measured. So it got me thinking, who was advising the Prime Minister then? Was there perhaps somebody close to Google working at number 10? Was there perhaps somebody in a personal relationship with somebody at number 10 working there advising the Prime Minister? I'll just leave that one hanging there, Madam Deputy Speaker. But thank goodness we now have the honourable member for Hove and Portslade to be advising the Prime Minister much more sensibly when it comes to these type of issues. And I want to come back, I see the whip nodding ahead there. I'm going to come back to Google because there are lots of important things to be said about this, because we have got to understand what this has all been underpinned by and the impact and the damage that this type of process is doing. Now, the Prime Minister dispatched Ian Hargreaves to solve this Google conundrum. Ian Hargreaves, quite conveniently, quite rightly, dumped all the Google nonsense as soon as he could. And what he therefore did was went to the United States to see if he could introduce the American system of fair use into UK law. When he was prohibited from introducing fair use into UK law because of very sensible European legislation, he then got on to the substance of what we started to do with Hargreaves, and that was to look at the economic contribution of IP. And he came up with these recommendations, 10 recommendations, some of them good, some of them bad, some of them indifferent, some of them repetitive, but he came up with the 10 recommendations which the government were of a view to accept. And since then, throughout this Hargreaves process, we've been in the business of legislating for these 10 recommendations. Some have required primary legislation. We saw that in the regulatory reform bill. Some of it has required secondary legislation, and some of it will require statutory instrument. Now, we've still got to see the statutory instrument because we're not quite concluded with the Hargreaves process. Yes, we've got this bill, we've got the SIs that are coming forward. And the one thing I'd like to hear from the Minister, and he could intervene if he wants, if not, hopefully he's summing up, he'll be able to tell us what on earth is happening with those SIs for the rest of the copyright exceptions. Now, you'll probably say something about the fact that they're still with Parliamentary Council and they're still being determined and they're still being ready to be presented and shaped up. Well, you better get a move on because he's only got to March to do this. So I'd like to hear pretty soon from the Minister just about the process, about what we should expect. Could I suggest to him something very strongly? And I think several of us in this House have said this several times to various ministers when it comes to these things. We have to see separate statutory instruments for each of the copyright exceptions. We have to see that as a matter of principle. It's right and proper that we're able to assess each of these exceptions on their own. I think it would be unacceptable to bundle them together on a take it or leave it basis, particularly the new exceptions, and there's some really important new exceptions there, things like parody, things like copying, things, you know, like all the other ones which I can't remember what they are, but you know the ones that I mean. And I think that we have to ensure that we get to see them separately and we get to debate them properly when it does come through. So we're getting close to the end of the Hargreaves process. Has it been good? Yeah, some of it's been all right. The Digital Copyright Exchange is fantastic, really good, great little innovation, part of the Hargreaves process that's worked. A lot of nonsense, a lot of stuff that we didn't need. And what it has done, and this is a lesson I think we've got to learn very carefully as we go through this. And one of the things that we could pick up was the great unhappiness this caused in so many of our creative industries. People who represent the creative industries coming to government, stating their very strong concerns about some of these exceptions being dismissed, arrogantly dismissed, as if they didn't understand the environment they were working in, that government knew better or Hargreaves knew better than them. These are the people that have built this success, being told they didn't understand the environment they're working in. There was a great deal of unhappiness from the creative industries, and there was certainly a lot of dissatisfaction and people feeling all out of sorts with the way that the government went about this business. So I hope if we do have a process like this in the future, we'll be able to look at this much more circumspect and we take everybody with us as we go forward. I'd also like to mention just a few remarks about the way this bill's been handled. I, for one, Madam Deputy Speaker, think it's an absolute disgrace that it's been the House of Lords that's looked at this first. This should be in this House. The value that IP plays to industry and business in this country means it's elected members that should be looking at this first. If the House of Lords want to have a little look at it and suggest amendments and things that we should look at and come back and consider again, that's absolutely fine. But something as important as intellectual property and its contribution to the economy should be handled by directly elected members. And it's an absolute disgrace that the House of Lords got to look at that first. Talented and some well-respected individuals, some of them they may be, but it's the right and responsibility of members of Parliament. The Minister responsible for IP is an unelected Lord himself, and I think the member for Lewisham South, East, it was spot on. Anonymous. West. Lewisham somewhere. And he's absolutely right. The Prime Minister couldn't even remember the name of the IP Minister. What chance have the rest of us got? And we should be able to question the Minister when he comes in front of the House so we can actually have a look at this. Now, it's great that we've got the Minister here. And who better, Madam Deputy Speaker, than a Minister with a multiplicity of brains dealing with a bill on intellectual property? But I tell you something, it should be the proper IPO Minister that is here taking this legislation forward. We welcome the Honourable Gentleman, but we need to see the IPO Minister in this House himself, and he should be accountable to directly elected members of this House. And what about the way all this is handled? I think a couple of people have touched on this so far. We have an unelected Lord accountable to the Department of Business, Innovation and Skills, which is responsible for the Intellectual Property Office, which looks after all the things that the Department of Culture, Media and Sport does. Is there anything as ridiculous as that? All the disciplines that the IPO manage and look after and support is in the DCMS. The IPO is in BIS. Surely we should be trying to bring that together. And the all-party intellectual property group, and to my fellow officers here, I'll tell the Honourable Gentleman, he's the secretary, by the way, of the IP group. But I can see some of the officers here today. And what we suggested is that that should be all brought together. We suggested the Department of Culture, Media and Sport is the perfect fit for the IPO, so it could be working beside all the industries that it's there to support. And I hope once again that we have a look at this and we can be able to resolve it. We also suggested, and I can't remember if we mentioned it, about an IP champion. That was what we said. Somebody, if it's going to work cross-department, we need somebody out there banging the drum for intellectual property supported business and industry. We've not had that just now. It's the great forgotten when it comes to all this. And I know there's people here who are passionate about IP and recognise its value and importance, but this place should be mobbed. It should be full to the gunnels. You know, this is something like billions of pounds that we've got to get this right. And of course, that's because of the way that we have an anonymous minister and a department that doesn't serve the industries that's supposed to be there. So please, come on, let's get this fixed out. Make the honourable member for Hove and Portslade our IP champion and IP czar. Get him out there getting things fixed out. And he was right to mention the IP czar from the United States. A fantastic job she's doing. We actually met her in the group and we were all very impressed with the power and the clout that she's got in Capitol Hill to get things done. That's what we did in this country. Somebody who will work cross-department, get things fixed out, gets things resolved, and make sure that we can able to take this key thing forward. Now, the bill itself. I'm not wanting to be repetitive, but we've heard so much. We can't, come on, we've got to get the context properly. We have, I don't want to be repetitive because we've heard exactly the sort of things it does. I mentioned to the Minister our concern about design. Now, it's great that registered design will be covered in this. It was the great unforgotten IP right was design rights, registered design rights. And it's fantastic that ACID have at last got their way, that this will now be covered by criminal infringement. But it is absolutely and totally wrong that unregistered designs aren't covered too. And I think we have to get this resolved. Now, there was a big debate down in the House of Lords about this on Clause 13, as it's called. But not only has there been a debate in the House of Lords, and there has been a debate within the industry. And I think there's now become a consensus where industry agrees that if we're going to proceed and pursue this idea of registered design rights, unregistered design rights must be included. The vast majority of people who work in the design industry are in small and micro businesses, probably less than 4 people working for them, and they cannot spend all this time making sure that things are registered. We've got to include unregistered. Of course, I give way to the Honourable Gentleman.
Speaker, I've listened very carefully to the arguments about this matter, and I just wonder how you can police unregistered designs. How is that going to be possible when no one's actually said, this is my design, and someone said, yes, I agree? How do you police it? And that's really worrying.
I mean, the ACID itself have got a database built up of unregistered designs of tens of thousands of people who have registered with their database. If a small organisation like ACID runs so efficiently and effectively with Dids McDonald with their very small staff can secure and achieve that, surely the UK government can. And that's what we're asking them to do, to ensure we get that in place. And it's absolutely right that we make sure that our design industry is properly looked after when it comes to this. Another thing that this bill is doing is it's once again making sure that we do make progress when it comes to patents and design. And I think that we all welcome it. What we need is a decisive leadership, not another piecemeal bill that does the absolute minimum that's required. And then we come to, of course, to the United European Patent Court. And this really has to be resolved. I didn't expect to be raising a constitutional point when it comes to these issues. But this is a serious point for Scotland and our ability to look after and judge and make rulings on our ability to decide on patent issues within Scotland. Now, the Minister knows, under the new regime, the all-European regime, we're allowed 4 divisional courts. That's every member state is allowed the 4 divisional courts. We know there's going to be one in London, so the government said that. We don't know where the other 3, if there's going to be another 3, but they've not said how many they're going to choose. One of them has to be in Scotland. We have to have that in Scotland. We cannot have our economy suffering because our inventors, creators and small businesses would have to leave their jurisdiction to secure justice and satisfaction elsewhere in the UK or further abroad. We can't have that. We've got to make sure that after centuries of looking after these issues, this is going to be available to the Scottish judiciary. Now, you've probably seen the letters from the Law Society of Scotland and the Faculty of Advocates in Edinburgh who are very, very concerned about this, because what we could be doing is diminishing and getting rid of not just decades but centuries of experience of dealing with patent law according to Scots law. So we've got to make sure that this Court of Session in Edinburgh becomes one of the divisional courts of the new unified court. I see the Minister. Yes, absolutely.
Because several members have raised this issue, and let me just make clear that, of course, as he rightly knows, London will be one of the divisions. How many divisions there are and where they will be will depend on the pattern of need and demand. We absolutely understand the importance of accessibility to these services across Scotland. We are working closely with the devolved administrations and the court services in Scotland and indeed Northern Ireland. So I can't give the honourable member the assurance he's asking for today, but if, as we see the pattern of demand emerge, and if we have good conversations, then it is very possible.
Very, very grateful to the Right Honourable Gentleman for saying that, and it does bring a degree of comfort, and I recognise that there is an attempt to try and resolve this. There's certainly, from the Minister, a recognition that this is a huge issue for us that has to be resolved, and I mean that all of the Scottish legal establishment is united in calling for this, and I think that we do welcome what the Minister said, and I really hope that as we perhaps take this bill through, we'll hear more about this, and we're able to try and ensure that the Scottish courts are satisfied with this and that we do not lose the centuries of experience of dealing with patent issues in the Scottish courts. So I thank the Minister for that. I also want to say a few words about Clause 21, the part of the bill that requires the Secretary of State to make this report about the activities of the IPO and how it supported innovation and growth in the United Kingdom. This, again, I don't think you'll find any argument from anybody in the House. This is very much a positive step, and it provides a bit of a focus for the IPO's activity. However, any measure must be quantified and include some reference as to how the IPO's activities have supported IP-dependent businesses and IP rights. One of the major battles throughout the Hargreaves process was all the stuff about economic evidence. And I remember when the creative industries used to come and present as evidence, and it was dismissed by Hargreaves himself as lobbynomics. That's what he referred to it. This was work that the creative industries had did to try and inform government about its activities, sometimes commissioned by the government itself, dismissed arrogantly as lobbynomics. Then, on the other hand, we had some heroic assumptions from the Intellectual Property Office to support its copyright exceptions. I think these said if all the 10 recommendations from Hargreaves was introduced, this would do something like 0.6 to 0.9% of GDP. Come on. They expected us to believe that. So this works both ways. And some of the other heroic assumptions that underpinned these copyright exceptions in terms of the support for that were almost totally unbelievable. And I remember, again, we in the IP group asked the intellectual property officers to come forward and explain some of these, and we found what they had to say totally unsatisfactory. So when we are coming to this annual report, it has to be credible, it has to be robust, it has to ensure that it's respectful to everybody within the sector, and it's not just left up to the Intellectual Property Office to come up, concoct some figures and expect us to be happy with them and satisfy them. It has to be a point where we're able to challenge them and have a look at what underlines some of these assumptions, because we cannot have some of the nonsensical economic assumptions that we had in the past when it came to some of these things. Lastly, I want to come back to Google. This all started with Google, didn't it? The Googlesburg Address and the way that this all was kicked off. Let's try and turn it on its head just a little bit. Because it was all about whether a Google could emerge in the UK because of the restrictive IP practices. Let's just ask, what about having a look at Google itself? Google is a digital behemoth. There is nothing bigger than Google when it comes to the digital world. It is the gatekeeper for all our content industries. Nothing happens without Google. Nothing could go through its prism without being able to satisfy it in some sort of way. It distorts the digital market, and one thing that it's damn well good at doing is ensuring it keeps its predominant position when it comes to this. All of its activities are there about maintaining its predominant, almost monopoly position as it comes to being our gatekeeper of content. Now, it produces no content of its own, not a bit, but yet again, it's all down to how all this content is measured and assessed. Now, somebody referred to the... Yes, of course, give it to them.
As a matter of fact, what the honourable gentleman just said about Google not producing its own content is inaccurate, and it strengthens his argument to acknowledge that they do produce content, for example, maps. And he's probably aware of the fact that the European Commission are, at this very moment, looking at the uncompetitive behaviour which Google are engaging in, putting their own products above other people's projects in the search engine.
I'm grateful to that. Maybe I was a tad too harsh when it comes to producing some of its contents. Yes, it does copy maps and put them up and make sure that people get access to them. But in terms of what we understand and appreciate as content, that's, whether that's a drama, whether a film, whether it's a television, whatever, it produces none of its own. All it does is put it as a platform, about the only platform that people use. And I think that it's some time this government is going to have a proper look at the almost monopoly status of this huge, multinational, non-UK business and ask whether this is good for our content industries. I have a sneaking position thinking it's not. And I saw the stuff from the BPI. It sent 5 million notices to Google asking them to take down links to illegal sites. Links to illegal sites, this is. They shouldn't be doing this. What on earth is going on? 5 million notices asking Google to take down links to illegal sites. If you ran, Madam Deputy Speaker, searches for MP3 downloads for the top 20 singles or the top 20 albums for the whole of November in Google, on average 77% of first-page search results for singles and 64% of first-page search results for albums would direct you to illegal sites. Isn't that incredible? When you put in the name of a band and you want to find some of their musical content, you will be directed to an illegal site through Google. What on earth is going on with this? As the BPI say, Google in its monopoly situation leads to a murky underworld of unlicensed sites where they may break the law because it persistently ranks such sites above trusted legal services when consumers search for music to download. It's time to call in the Monopoly Commission, I think, when it comes to this. We cannot continue to go on allowing Google to be this gateway to our content industries when they're doing so much damage to our industry just now. And I met the Featured Artists Coalition just before Christmas, and I had a fascinating chat with them. They represent some of our greatest pop stars in the course of the past 50 years, people who have made millions and millions of pounds for the UK economy and also given us great entertainment throughout the years. Crispin Hunt is one of the spokespeople for the Creative Coalition. And what he said about this, and this just sums it up perfectly, A brilliant new band that I recently worked with has just been dropped by their label because their debut EP sold barely 4,000 copies. Yet the #1 site on a Google search for the same EP boasts of 23,000 illegal downloads. Then it directs me to an online brothel, next to an advert for Nissan, as I rip the tunes. What more do I need to say? What more does he need to say until we get something done about this and to ensure that something is done about the monopoly status of Google? And I hope that now we're through or concluding the Hargreaves process with this bill, we start to look at how people access content, how content is distributed, and how this is distorting the market and ensuring that our artists, our inventors, our creators are properly rewarded for the work that they do. I hope to serve on this committee as we go through. There's a number of outstanding issues, things that we need to look at, and I'm looking forward to the Minister's response. He's got those two brains of his, so we could get thinking on this intellectual property bill, and I hope that these two brains will be in the mood for accepting some helpful amendments as we try to improve this bill and make sure that we do secure satisfaction for our creative industries and for our artists and creators. It's an adequate bill, it's a piecemeal bill, it's the only bill we've got. Let's get this done, let's get finished with the Hargreaves process and move on to the substantial and real stuff that we need to do, and that is keeping and ensuring this country remains at the top of all cultural and artistic disciplines as we go forward into the next decade.
Mike Wetherley.